Hello, everyone. Welcome to another episode of the Lifetime Legacy Lawyer Podcast. Thomas Vick here with Seth Wilson. Seth, how's it going today?
Yes, I'm doing great. As I mentioned to you before we jumped on our recording call, I had a out of county court hearing today, so just traveling back from that and excited to jump on the call and talk about some of these important estate planning topics. We were fortunate to help out with an adoption today and just think about that concept of bringing someone new into your family and the importance of that situation for the child, but also in terms of considering your estate plan, because now that child is part of the family to be planned for. So that also kind of brought up the sibling question, and I noticed on your blog digest that you've got an interesting article titled "Can I Sue My Siblings?" And so I thought we might want to chat about that today.
Yeah, so the blog article is a little bit of a summary of an article that was entitled from Morningstar, My Brother Won't Tell Me Anything About Our Mother's $1.6 million estate. Can I remove him as trustee? So that's kind of the intriguing headline that the article talks about. And, when we were discussing what we're going to discuss on the podcast, you said, well, yeah, absolutely. You can sue for anything, right? But yeah, it's definitely a possibility, and some forethought should go into, the parents or whoever's creating the estate plan to think about who are the personalities involved. Is somebody going to feel mistreated or slighted? Do siblings not get along well? What kinds of things do I need to plan for to make that transition of assets make it have the least amount of conflict possible? And the article goes through pitfalls of some estate planning or lack thereof, and the first one is failure to communicate. And I always love to hear it when clients say, okay, I've got my estate planning binder now. I want to give it to the family so they have a copy of it, so they understand what's going on. And, that's just so key, so that you can set expectations while you're living. And then after death, your loved ones will be able to know what to do. Nothing will be a surprise to them. So I think that's maybe the best place to start, is to communicate your wishes to your loved ones.
Yeah, and I think to piggyback on that is the personal representative or the trustee or the siblings in this particular scenario. Communication among the siblings is really important, because even if nothing is going on or you don't have the answers yet, that lack of response can breed some suspicion, or our brains naturally try to fill in the gaps where there may be missing information. And so keeping that open line of communication between siblings, I think, is really important, especially when one sibling has information. And we know knowledge is somewhat equated with power in our society. So you just want to make sure you're trying to balance the playing field as much as you can. And one thing we often say is, when an attorney gets bad news for a client, that's probably our least favorite phone call in the world, is to pick up and give bad news. But don't wait. Like, if you have bad news, it's better to get it out there quickly. So if the sibling has been disinherited, for example, it's probably a good idea to get that communicated relatively quickly, so that sibling doesn't have additional reasons to be upset about things, because maybe mom or dad had a different reason for the plan that they left in place.
Yeah. Another pitfall that is mentioned in the article is trust left unfunded. The article talks about, you got a $1.6 million estate, but there had been some kind of irrevocable trust that was created during the grantor's lifetime, but that trust was never funded. And so it didn't do what the person who signed up for the trust wanted it to do. And so that caused an estate problem that the family had to pick up and deal with. So that's one of the key conversations that I have with clients right after we sign a trust document. We talk about, what do I need to do to fund the trust? How do I get the house into the trust? How do I get the bank accounts into the trust? What investment accounts can go into the trust? All those conversations, and then the follow through of actually transitioning those accounts and other properties into the trust is essential. And I've stolen one of you. I don't know if I've stolen it or you took it from me, but the idea is to do the probate work while you're living. You're funding the trust. It's really like doing the probate process while you're living. As our minds have kind of melded together over the years of the podcast here, but you gotta fund the trust, and if not, you're potentially going to have a probate estate subject to any kind of Medicaid estate recovery claims and creditor claims and things like that.
Yeah, it's such a great point because the funding piece is the most difficult, if you will. Once you've kind of put the plan together and gotten the trust in existence, then actually putting things into the trust or in the name of the trust, which is all funding is the next step. And that analogy, it just helps me think about, how do I explain the difference between a will-based plan and a trust-based plan? And really, with the will-based plan, you're just kind of mirroring what's happening during life, and then at death, the will be utilized to direct the personal representative with what to do, versus the trust, where you're setting that up as sort of a companion document for you during life, and you're the one taking those steps to put items into the trust or designate the trust as a beneficiary. And so, very important piece of the puzzle. And I find where this comes up quite a bit, Thomas, is when one of the spouses is convinced that a trust-based plan is the right thing for their family, and the other spouse doesn't really have as much engagement in that process and may not understand what it is. Or in the article, it mentioned sort of the Medicaid side of things. Maybe an event occurred and it was unexpected, and so you got partway through the process but were unable to finish it. But again, that's one of those things that can definitely cause some challenges among siblings if that piece of the puzzle is left undone.
Yeah, absolutely. Making sure that you're on the same page with the spouse and setting up a trust is really critical, so that you can have a trust and make sure it functions the way that it's supposed to. Another pitfall of common estate planning pitfalls is no will being filed. So, it might be that there's just a lack of communication about what's happening with the estate, and then you're kind of looking at the public records and the will hasn't been filed, but you've got, maybe the personal representative named in the will doing some things, and then that breeds suspicion. And maybe the personal representative doesn't know that he actually needs to file the will, because the will really isn't enforced until you've actually probated it and gotten it approved by the court. And so that can cause some conflict, some commotion, if you will, among siblings if you just don't have a will filed.
Yeah. And that's often the case because, again, as we talk about the difference between a trust-based plan and a will-based plan, if you have a will-based plan, most of the time you're going to need to probate that will to give the personal representative the authority to act on behalf of the estate and do the things necessary as set out in that will. And so whether there's some question as to what authority was given to the personal representative and what the actual disposition plan was and all of the steps that need to be taken there, that lack of clarity can breed questions, especially when you're talking about siblings needing information. And so trying to keep everybody involved and up to date on the communication piece is really important. And I think that's kind of the highlight of this whole section. And one thing just to point out is these sibling disputes could also arise if there is a during life incapacitating event, and the siblings are named as joint powers of attorney or not co, but one after the other powers of attorney. Who has the authority to act? What if we don't agree, if we're joint powers of attorney, on what to do? And so sometimes I think even in those situations, just a call to the lawyer can be helpful to say, what are the roles and responsibilities here? And work through that together if possible. Sometimes the situations may require both siblings to have their own lawyer, and try to figure things out. But I think you mentioned that as part of the potential resolution to these issues in the article.
Yeah, and one of the other things that I was thinking about on this topic is, well, you've got some legal rights that individuals have with respect to an accounting and things like that, and so maybe we're not able to get to a resolution when it comes to the attorneys in fact agreeing, or maybe it's an attorney in fact and a sibling. What can that sibling do if he feels like the fiduciary isn't, living up to his or her duties?
Yeah, as I mentioned just a moment ago, if they retain their own attorney or send a letter or do something to that effect, they can request certain things in terms of an accounting or what has transpired. So if they're a beneficiary of the trust, for example, they would have a right to see part of the trust document, and in most cases. And that sort of determination could involve the court, where there's a petition filed with the court to say, let's hit the pause button here, and maybe the personal representative needs to be challenged here, and we need to appoint a special personal representative or administrator to handle these affairs, or let's just put the trust in front of the court, called docketing the trust, to see what needs to be done. And so there are some options to help through that. But again, if there's an ability to communicate and work through those issues, either by virtue of lawyer to lawyer, sort of being the intermediaries, or maybe even submitting the situation to a mediator to help work on things, because all of these things will cost the estate or the individual financially from an attorney fee standpoint, potentially, right? So you want to just be cognizant of that and not really use up estate funds fighting over who gets what if you can avoid it.
Yeah, absolutely. Yeah, and another option that is available is, besides just removing the personal representative, that you could maybe have a trustee. We think about trusts avoid probate, but when there are issues that come up, the probate court is the court that has jurisdiction to handle trust issues, trust conflicts, and controversies. And so it might be that there needs to be a petition to remove the trustee for failure to meet its fiduciary responsibilities. So that may be a remedy that a beneficiary of a trust can seek. So yeah, there are a couple of different ways. I guess there's a whole multitude of ways that heirs can approach legal problems like that. But they certainly have avenues in which to be heard by the court. Anything else on this topic, Seth?
I think it's just one that is very common, and one I think our approach is always to help those who are writing their plans do so in a way that considers these potential issues, and tries to address them through the plan at the front end if possible, really to promote as much family harmony as we can through these situations, because these types of arguments are very deep in terms of their emotional impact and psychological situations that are going on, and can last for a really long time. And they may involve things that, a family history of 30, 40 years and you may have a very difficult time getting to a resolution as a result of that. So with the clarity that you can provide, that's what we help our clients try to figure out. When we do know there's going to be some potential for issue down the road, how do we approach that? How do we best prepare the plan to get us through that time with a minimal amount of controversy?
That perfectly leads us to the next topic, and that is, what estate planning documents do I need? And got a list there in the blog of what documents you need to have at minimum, but also some other documents that could be a wise route to go depending on what the family dynamic is and what the individual's goals are. And so, we talk about this, this list of documents that everybody needs to have quite a bit. We probably don't do it enough, though, because there are still people out there that do not have estate plans. So until everybody in the state of Indiana has an estate plan, we're going to keep on talking about it, right? But one of the things that is mentioned is it's not just for the wealthy. Estate planning is not just for the wealthy. You were talking about these emotional troubles that happen whenever there are disputes among family members. And so we're not just planning for money and, large accounts to be divvied up among family members, but we're promoting family harmony in a lot of ways. Whether, no matter what socioeconomic class we may be in, we're definitely trying to make sure that there's a smooth transition from one individual to another.
Yeah, and as you mentioned, Thomas, this will sound repetitive for people who watch this a lot because we talk about very similar solid plans, but there are still statistics out there that are very surprising in terms of folks who don't have these plans in place, or maybe they started the plan and never quite finished it, or usually some type of event, a life change or a diagnosis, or somebody experiencing something in your network reminds you that, boy, I really need to get these things done. And so it bears repeating that you need to have that last will and testament. You need to have your powers of attorney for financial purposes and for healthcare purposes. You need to consider whether you want a living will or an advance directive. And you want to consider if you need a trust. And though, again, we won't go through those in detail, but this list is always good if you're approaching this for the first time and just not sure what the full elements of an estate plan are. Or maybe you've put it off for a while and need to really get back to or get your plan updated because it's been a few years. So always worthwhile to remind folks to do that and work with an estate planning professional to get those things done. And then, Thomas, one question we often get is sort of how do these plans interact with other financial arrangements that I have, like life insurance? And you had an interesting post up on your blog about life insurance. So kind of walk us through in general terms these beneficiary designated assets. How do they work inside of an estate plan?
Yeah, and often we don't really think about designated beneficiaries a whole lot in estate plans, but really clients need to talk to their attorneys about particular designated beneficiary selections, because oftentimes, whether it's life insurance or retirement accounts, those are the biggest assets, or at least one of the biggest assets that people have in their estate. And if that's not reflective, if it's not planned for, then maybe we can make a mistake with some large assets. And the one topic that's really discussed in this article is about life insurance and how you can use life insurance to get some income tax savings and estate tax savings. And it's kind of under the context of the estate tax exemption levels are going to be changing here in about the next year and 3 months. So year and 4 months. So January 1st, 2026 is coming up pretty soon, and if nothing happens in Congress, then we're going to have some more estate tax planning to do from an estate planner perspective, because there'll be more people that are nearer that limit. And irrevocable life insurance trusts are one of the ways of planning to save when it comes to estate taxes. And I won't go into too much detail as we're 20 minutes already into this podcast, but maybe we just kind of sock that one away and say, hey, if estate tax is a concern for me, then I should be looking into an irrevocable life insurance trust.
Yeah, it's a good way to think about that. Anytime you have these beneficiary designated accounts, they are their own mini estate plan. And some of them actually are trust agreements with whoever the plan holder is. But with life insurance in particular, there's a lot of special rules associated with it. And so you want to just be cognizant of how that's going to work in your plan and work with your plan, because in general terms, if you bring that asset to your estate when you pass with the asset, it will affect your entire estate value. Even though it's beneficiary designated, it is considered an asset. So if you have a $500,000 life insurance policy, that is an asset to be added into your total estate value, which obviously has probate implications if you have otherwise a small estate. But for the life insurance, you could have a situation there where you want to address those kind of things. So it's just one of those that often will get missed in the discussion because it's sort of over here, but it is potentially going to become even a more important tool in your toolbox as the laws change and we see what happens in 2026.
Great stuff there. And also, I would just note that life insurance is great because it's not taxable from an income tax perspective. So when people get $100,000 of life insurance proceeds or $500,000, they're often shocked. I don't have to pay any taxes on this. No income taxes, and that's a beautiful thing. So, I'm not a financial advisor, but life insurance is great because you're able to avoid having to pay income taxes on it.
Yeah, and so again, just another tool in the toolbox to kind of think about, but I think highlights the importance of what we've said before on the podcast as well. Is this is a team effort. It involves your attorney, your financial planners, potentially a life insurance agent now. So and sometimes I know those can all be combined together in some ways. So just make sure that as part of that team, the estate plan overlap is discussed and addressed appropriately in your plan.
Absolutely. Well, I think that about does it for this episode. Seth, how can people get in touch with you?
Thomas, I am located in the heart of Hamilton County up in Noblesville, Indiana, on the north side of Indianapolis. And that's our web address, noblesvilleattorney.com. How about yourself?
Best way to get in touch with me is by going to viclaw.org and select book a call, viclaw.org, and select book a call. And I'll just make a little plug here that my office is going to be moving to a different suite, same building, but a different suite. I'm going to be in suite 113 beginning next week. So I'm looking forward to that. So a little announcement on Vic Law PC here in Greenwood.
Breaking news. You heard it here first. That's awesome.
But that's it.
Well, it's great to see you.
We'll talk to everybody next time.
Sounds good, Thomas. Thanks.